3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through the evidence seized. Today, we are following bail hearing through the documentary record, so the timeline, decisions, and institutional failures are clear. As always, every document and source we reference is available at epsteinfiles.fm. So start with $500 plus assets revealed. That is where the paper trail becomes specific and testable.
That number is the starting point for everything that follows in 2019, $559 million.
A very specific figure.
It is, and it's important to understand where it comes from. This wasn't a number the government came up with. This was the defense's own disclosure.
It's in document EFTA 0016124.pdf, the financial affidavit they filed.
Correct. They presented this valuation to the court. The strategy was clear: to demonstrate overwhelming financial capacity.
To show they had more than enough collateral to secure any potential bond.
Precisely. In a typical case, that's a sound strategy. Show the court you have deep roots, significant assets you'd never abandon. But here, the prosecution completely inverted that logic.
Let's break down the composition of that number first, because it's not just a single figure, it's a portfolio. And the nature of that portfolio is key.
It is. You have several categories of assets. The most visible, of course, is the real property.
Manhattan residence on East 71st Street, the one where the search warrant was executed.
That's the one. Then the Palm Beach estate, the New Mexico ranch.
The Zorro Ranch.
Correct. And then the international properties, an apartment in Paris, and the 2 islands in the U.S. Virgin Islands.
Little St. James and Great St. James.
Yes. So that's the fixed asset base. But the disclosure goes further. It details very significant cash reserves.
And this is the critical part. We're not talking about wealth that's tied up and hard to access.
Not at all. The filing lists substantial holdings in equities and fixed income investments. This is liquid wealth. It can be moved, transferred, and converted to cash on very short notice.
So the argument from the defense is, look at all this property, he's not going anywhere. But the liquidity tells a different story.
It tells a story of capability, and that's before we even get to the aviation assets.
The private aircraft.
Plural. A Gulfstream G550, among others. These aren't just assets in a portfolio. The government argued they were tools. They were logistics.
The means of flight.
The means of flight sitting on a balance sheet. The defense presented it as proof of stability. The prosecution reframed it as an escape plan waiting to be activated.
Which leads directly to the defense's central argument in the bail hearing itself.
It does. We can see it in the transcript, document EFTA 00018384.pdf. There's a moment where the defense counsel makes an extraordinary offer to Judge Berman.
They say he can meet whatever bond you want.
Whatever bond you want. It's an attempt to make the amount of the bond a non-issue. To say, name your price for his freedom pending trial.
They're trying to leverage the balance sheet directly to solve a liberty problem with a financial transaction.
And in most white-collar cases, that might have worked. A court sets a high bond, the defendant posts it, the system moves on.
But the prosecution had a specific counter for this. It's laid out in their filings, particularly EFT 0003024.7.pdf.
It's an economic argument, and it's quite compelling.
They argue that for a defendant with this level of wealth, a financial bond loses its power as a deterrent.
Exactly. They talk about the marginal utility of money. The idea is, if you're facing what amounts to a life sentence, 45 years, at his age, what is the value of your freedom?
It's almost infinite.
So then what financial penalty could possibly guarantee you'll show up to face that sentence? The government did the math. Let's say the court sets an unprecedented bond, $100 million.
Okay.
If the defendant flees, he forfeits that $100 million, a huge sum. But he still has over $450 million left.
More than enough to live as a fugitive in extreme comfort for the rest of his life.
Correct. The prosecution's line was that the bond wasn't a guarantee of appearance. It was simply the price of escape, a fee, a cost of doing business to avoid spending the rest of your life in federal prison.
So the very asset the defense used to argue for his release, the immense wealth, became the primary reason the government argued he had to be detained.
It's a perfect inversion. The wealth was no longer a shield. It was the weapon the prosecution claimed he would use to flee.
And this wasn't just a theoretical argument about money. The government then built a case around the actual physical means of flight.
Right. This moves us to the second block of evidence. They had to connect the money to the method.
The documents for this are EFTA 000-15661.pdf and EFTA 000001663.pdf, the government's detention memo.
And they built this argument on three pillars. The first was the private aviation we already mentioned.
The ability to bypass standard security.
It's a critical point. A private jet owner doesn't go through TSA. They don't have their name on a commercial passenger manifest that gets flagged in government systems. They can, with relative ease, fly to countries with more flexible entry requirements.
The second pillar was the international property, the apartment in Paris.
A potential safe haven, a place to land and disappear into, where he already had a foothold.
But the third pillar was the most concrete piece of evidence, the contents of the safe.
This was the anchor for the entire flight risk argument. During the search of the Manhattan residence, the FBI found a locked safe.
And inside?
Alongside a large amount of cash and loose diamonds, they found a passport.
Not a U.S. passport.
No, an Austrian passport. It had the defendant's photograph.
But not his name.
A different name entirely. And, most importantly, the listed residence on that passport was in Saudi Arabia.
A country with no extradition treaty with the United States for these kinds of offenses.
A very difficult place for U.S. law enforcement to operate. The defense, of course, had an explanation.
They claimed it was old, expired.
They argued it was from the 1980s, a security measure obtained because, as a wealthy Jewish businessman, he faced kidnapping threats. They tried to frame it as an archaic, irrelevant document.
But the court didn't see it that way.
No. Judge Berman's detention order notes that possessing a document like that, even if expired, shows a specific mindset.
A preparatory mindset.
That's the phrase used. It demonstrates that the defendant had, at some point, actively contemplated and acquired the tools needed to assume a false identity and live abroad undetected. The fact that it was kept in a safe with cash and diamonds
suggests it wasn't a forgotten relic. It was part of an emergency kit.
It was part of a contingency plan. And that plan looked a lot like fleeing the country.
The defense tried to counter all of this with legal precedent. They cited a specific case.
They did. Documents EFTA 00000018441 and EFTA 0000000018466 both reference the Thompson case, United States v. Thompson.
What was the argument there?
It was an attempt to show inconsistency. In the Thompson case, a wealthy defendant had been released on a $500,000 bond. The defense was arguing for equal application of the law.
You let him out, so you have to let our client out.
Essentially, yes. They were trying to paint the prosecution's stance as an unusual deviation from the norm for affluent defendants.
But Judge Berman rejected the comparison.
He distinguished the cases on the basis of scale. The defendant in Thompson had money, he did not have a private air force, multiple international homes, $500 million in liquid assets, and a fraudulent foreign passport in a safe.
So the court's reasoning was that, at a certain point, the sheer magnitude of resources changes the entire equation.
It creates a different class of flight risk. Judge Berman ruled that the Thompson precedent was simply not applicable because the capabilities were on a completely different level. There's a threshold where wealth becomes a super enabler of flight, and he ruled that this case crossed that threshold.
There was another, more procedural argument the defense tried to make concerning SORNA.
Yes, the Sex Offender Registration and Notification Act. This is in document EFTA 000206661.pdf.
What was the argument?
They argued that using his past conduct, particularly the conduct covered by the 2008 non-prosecution agreement in Florida, to justify detaining him now was a kind of retroactive punishment.
That the government was changing the rules on him a decade later.
Right. He complied with the terms of the NPA, and now you're holding that same conduct against him in a new way. That was the essence of it.
But the SDNY indictment alleged a conspiracy that continued past the dates in that agreement.
And that was the government's counter. They argued they had new evidence of a conspiracy that ran from 2002 up to 2005, and possibly later. The court sided with the prosecution.
The ruling was that the bail decision had to be based on the current charges and the current risk assessment.
Correct. The terms of a disputed, decade-old agreement from another district couldn't tie the hands of the court in New York when faced with a new indictment and new evidence.
Which brings us to the ruling itself, the denial of bail.
Evidence Block 3, the actual decision. This is documented in EFTA 0000000000000025258.pdf.
Judge Berman's ruling was based on two distinct legal grounds.
Yes. The Bail Reform Act allows for detention if a defendant is proven to be either a risk of flight or a danger to the community. In this case, Judge Berman found that the defendant was both.
The flight risk finding seems straightforward given the evidence we've just discussed.
It was. The money, the planes, the passport, that was a clear-cut case for flight risk.
But the danger to the community finding is significant.
It's very significant. In many financial or white-collar cases, this prong isn't met. But here, the government presented evidence, what's legally known as a proffer, suggesting a long-standing pattern of predatory sexual conduct, specifically involving the recruitment of minors.
And the defense had a very specific, very unusual proposal to mitigate that danger.
They did. This is one of the most remarkable aspects of the entire hearing. They proposed what amounted to a private jail.
Let's unpack that. It wasn't just standard home confinement.
No. This is detailed in EFTA 000028785.pdf. The proposal was this. The defendant would be confined to his Manhattan mansion. He would pay out of his own pocket for a team of 247 armed security guards to monitor him.
Guards he would hire.
He would hire, and he would pay. He also offered to install a comprehensive video surveillance system and give the U.S. Attorney's Office a live feed. He would surrender his passports and deregister his jets.
From the outside, it sounds like a high-tech, high-security form of house arrest.
That's how the defense presented it. A gilded cage, but a cage nonetheless. But the court immediately identified a fatal structural flaw in the plan.
The two-tiered system of justice.
That's the phrase Judge Berman used in his ruling. He said the proposal would create one system for the wealthy who can afford to build their own prison and another for everyone else.
And the core issue was the payment structure.
It all came down to who signs the paychecks. The court's reasoning was simple. If the defendant is the one paying the guards, who are they ultimately loyal to?
I am a lawyer.
Their employer. The government argued this created an unavoidable conflict of interest. What if a guard sees a minor violation or a major one? Do they report it and risk losing a very well-paying job? Or do they look the other way?
It puts the guards in an impossible position.
It inverts the entire structure of custody. The court ruled that allowing a defendant to fund their own detention effectively privatizes the function of the U.S. Marshals Service. And that was a line the court was unwilling to cross.
There was even a proposal for a trustee to oversee the arrangement.
Yes, the defense tried to add a layer of legitimacy. They suggested appointing a trustee, a respected former law enforcement official, to manage the security detail and report to the court.
But the person would still be on the defendant's payroll.
That was the flaw the prosecution kept highlighting. You can't have a private warden paid by the inmate. The chain of command is broken. In a real correctional facility, the authority flows from the state. Here, the authority would ultimately flow from the defendant's checkbook.
So the court rejected the entire concept.
Completely. The order is in document EFTA 0001887.pdf. It's unambiguous. Remanded to the custody of the Attorney General, no bond.
And the designated location was the Metropolitan Correctional Center, the MCC, in downtown Manhattan.
Correct. From a private mansion to a federal jail cell. The court's decision was a total rejection of the idea that money could buy a bespoke form of justice.
So after this denial, the defense strategy had to shift. They had to argue against the court's findings.
Right. Evidence block 4. How they tried to push back? Their main argument is detailed in what's known as the 14-tag Epstein bail memo.
What was the core of that argument?
It was what you could call the status quo argument. They pointed out that the defendant had known about this renewed federal investigation for many months.
Since the Miami Herald series was published in late 2018.
Exactly. They argued that he had ample opportunity to flee. He was in France just before his arrest. He could have stayed there. He could have gone anywhere. But he didn't. He got on his plane and flew back to the United States.
The argument being that his return proved he wasn't a flight risk. If I were going to run, I would have already.
It's a plausible argument on its face. But the government had a counter for that, too.
Which was?
They argued his calculation of risk changed dramatically at the moment of his arrest. Before being taken into custody, he was likely operating under the belief that the 2008 NPA from Florida still protected him.
That he might face civil suits or financial penalties, but not a new federal indictment with a 45-year sentence.
Precisely. The government's position was that he returned to the U.S. thinking he could manage the problem as he had before. The flight risk wasn't based on his behavior when he felt legally shielded. It had to be based on his new reality, facing the rest of his life in prison.
So his past non-flight wasn't predictive of his future behavior under these new, more severe circumstances.
That was the government's argument, and the one the court accepted. The status quo had been shattered at Teterboro Airport.
The defense also tried to address the international risk with a voluntary waiver of extradition.
Yes, another part of their proposed bail package. He offered to sign a legal document saying that if he did flee to a foreign country, he would waive his right to fight being extradited back to the U.S.
And what was the court's view on that?
The court found it was essentially unenforceable, a piece of paper.
Why?
Because a waiver signed in New York under the threat of indictment has very questionable legal force in, say, a French court. He could flee to Paris, and the moment U.S. authorities tried to enforce the waiver, he could claim he signed it under duress.
And then the French legal system would have to spend months or years adjudicating that claim.
Correct. The court saw it for what it was, a promise that offered no real security once the defendant was outside of U.S. jurisdiction. It couldn't physically compel his return.
They also made a constitutional argument, a Sixth Amendment claim.
They did. This is in document EFTA 0000111096.pdf. They argued that the sheer volume of discovery material, the evidence the government had turned over, was voluminous.
Millions of pages of documents, hard drives of data.
Yes. And they argued that the conditions at the MCC, with its restricted visiting hours and lack of sophisticated technology, made it impossible for him to review this material and meaningfully assist in his own defense.
A violation of his right to effective assistance of counsel.
That was the claim. That detention was actively impeding their ability to prepare for trial.
And the court's response.
The court acknowledged the challenge, but it didn't find that it was grounds for release. The remedy wasn't to let him go home.
It was to improve the conditions of his legal visits at the MCC.
Exactly. The court ordered the MCC to provide him with a dedicated, air-gapped laptop loaded with the discovery materials and to grant his legal team extended visiting hours.
So it was a logistical solution to a logistical problem.
It was a decision that prioritized community safety and flight risk over the defendant's convenience. The court made it clear that the complexity of his alleged crimes couldn't be used as a lever to secure his release from custody.
Now, this entire 2019 proceeding needs to be put in historical context. It didn't just appear out of nowhere.
No, it is the culmination of a conflict that had been simmering for over a decade. This is evidence blank 5, the institutional decisions that led to this moment.
And the key document here goes back to 2006. The letter from Palm Beach Police Chief Michael Ryder.
The Ryder letter is the foundational text of this entire affair. It's a letter from Ryder to the state attorney at the time, Barry Krischer. And it is an extraordinary document.
Ryder is expressing his frustration with Krischer's office.
That's an understatement. He writes, and this is a direct quote, "I continue to find your office's treatment of these cases highly unusual."
Highly unusual. In the language of bureaucracy, that's a red flag.
It's a siren. Ryder lays out the facts. His police department had investigated. They had found probable cause for multiple felonies. They had victims willing to testify. They were formally requesting that the state attorney's office prosecute these as serious crimes.
And Krischer's office was balking.
According to Ryder's letter, they were pushing to treat the cases as misdemeanors. They were questioning the credibility of the victims. Ryder documents a fundamental disagreement. The police saw a criminal enterprise. The prosecutor's office was treating it as a series of isolated, ambiguous encounters.
Ryder even suggests that Krischer should recuse his office from the case.
He does, which is a serious step for a police chief to take. It shows a complete breakdown of trust. He believed the prosecutorial discretion was being exercised improperly.
So how does this 2006 letter connect to the 2019 bail hearing?
It's the baseline. It proves that the core evidence of a pattern of criminal conduct existed 13 years earlier. The facts presented by the SDNY in 2019 to argue for detention as a danger to the community are substantively the same facts Ryder presented to Krischer in 2006.
So the evidence didn't change.
The institutional response changed. In 2006, a state-level institution chose to minimize the evidence and offer a lenient plea deal. In 2019, a federal institution took that same evidence, plus new findings, and used it to argue for maximum security detention. The bail ruling was, in effect, a vindication of Chief Ryder's original assessment.
And this leads into the conflict over the non-prosecution agreement, the NPA.
The 2008 NPA, brokered by then U.S. Attorney Alexander Acosta in Miami. We see this discussed in documents ESA 0000133359 and EFTA 00011475.
A cost as justification for that deal often invoked federalism.
Yes, the principle that the federal government shouldn't intervene if a state prosecution is already underway. He used that to justify a deal that was widely seen as incredibly lenient.
But the 2019 bail hearing put that NPA under a microscope.
It did, especially regarding the victims. The core legal failure of the NPA was that victims were not notified of its existence before it was finalized, which was a clear violation of the Crime Victims' Rights Act, or CVRA.
And from a legal standpoint in the bail hearing, did that old agreement have any power to protect him in New York?
That was the million-dollar question for the defense. They argued it should, but Judge Berman ruled decisively that it did not.
On what grounds?
He ruled that a non-prosecution agreement signed by one U.S. Attorney's office in the Southern District of Florida could not grant lifetime immunity from prosecution by a completely different office, the Southern District of New York, especially for a new indictment based on new evidence.
So the NPA's protection was geographically and jurisdictionally limited.
And its secrecy worked against it. The fact that it was hidden from victims further undermined its legitimacy in the eyes of the 2019 court. The ruling essentially built a firewall between the failures of the 2008 Florida deal and the new case in New York.
It stripped away the legal shield he had relied on for over a decade.
It was the moment the institutional decision of 2019 corrected the institutional failure of 2008.
That brings us to the final evidence block, the unresolved gaps. The hearing established a lot, but it also pointed to what remains unknown.
Yes, and the most direct parallel we see is in the subsequent case of Ghislaine Maxwell. The documents are EFTA 00000000000000005 and EFTA 000000315A0.
When she was arrested, her legal strategy for bail was almost identical.
A carbon copy. She offered a massive bond, $28.5 million. She proposed home confinement with private armed guards. She offered to waive extradition.
And the outcome was also identical.
Bail was denied, and denied again on appeal. The court used very similar reasoning, but with one key phrase. They cited Maxwell's opaque finances.
Opaque finances, what does that signify?
It means that even with the financial disclosures she made, the government and the court could not get a clear picture of the full extent of her wealth, where it came from or where it was held. They suspected hidden assets.
And this reflects a gap in the original Epstein bail hearing.
It does. We have the top line number, $559 million. We know the major assets. But the full, intricate web of offshore trusts, shell corporations, and the flow of money between them, that was never fully audited or litigated in the context of the bail hearing.
The hearing focused on the amount of money as a flight risk.
Not the source or the movement of that money. That forensic financial tracing would have been a central part of the trial. But at the bail stage, the sheer size of the known assets was enough. The full financial architecture remains a significant gap in the public record.
And there's another gap, a more human one. The victim impact gap.
This is critical. We see it referenced in document EFTA 000000787, a filing that speaks of victims being robbed of their day in court.
Because the defendant's death meant no trial?
Exactly. And the procedural consequence of that is profound. The bail hearing was the one and only time that the evidence of his danger to the community was presented in a court of law.
The government proffered witness accounts and the findings from the Florida investigation to prove he was a danger and needed to be detained.
And Judge Berman accepted that proffer for the purposes of denying bail. But that evidence was never tested by cross-examination. It was never weighed by a jury. So the bail hearing transcript and the judge's order are the closest we will ever get to an official judicial finding of fact on the danger he posed to children.
Document ETO 00018867 also shows the struggle under the Crime Victims' Rights Act.
Yes, the CVRA gives victims the right to be heard at public proceedings, including bail hearings. The victims in this case fought for that right. The defense fought to exclude their testimony.
The court had to balance those rights against the presumption of innocence.
And while the denial of bail was a victory for the victim's immediate safety concerns, the ultimate lack of a trial means the full story, the full scope of the harm, was never formally entered into the legal record through a verdict. That remains a fundamental gap.
So if we synthesize the entire record of the bail hearing, what does it prove?
It proves, first, that a financial disclosure of $559 million intended to secure release was successfully reframed by the court as the primary justification for detention. An asset became a liability.
Second, It documents a clear judicial rejection of a two-tiered system of justice. The private prison proposal was shut down on principle.
Correct. The Southern District of New York drew a hard line against the idea that wealth could purchase a separate, more comfortable form of incarceration.
And third, it validates the evidence gathered back in 2006.
It does. The hearing connects directly back to the Ryder letter, showing that the factual basis for detention existed for 13 years, but was only acted upon when a different institution, the federal government in New York, decided to intervene.
The documents show the means, motive, and opportunity for flight were established. The danger was established.
And the decision to remand him to the MCC was the direct, logical outcome of that evidence. The paper trail is a documentation of a legal containment strategy that, unlike in 2008, held firm.
The timeline is clear. The assets were revealed. The risk was adjudicated. The bail was denied. The defendant was remanded to the MCC.
And that final decision to place him in federal custody based on the evidence presented in these documents set in motion everything that came next.
Next time, SDNY indictment.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.